qualify as small companies, this single shareholder, single director exemption doesn't quite apply to them. So while they can have a single shareholder, if you're not a small company, you will be required to have at least 2 directors. Now, a small company is essentially a company that has turnover of 120 million and net assets that amount to 60 million naira. In the old CAMA, the threshold was much lower, which was impractical because so for those of you who live in Lagos and you go to the markets, some of the women who sell provisions in those markets like Sura, their turnover was way more than what it was before, which was 2 million naira. So it didn't make sense. A lot of companies didn't qualify as small companies. Now that threshold has increased to 120 million naira for your turnover, more companies will fall within this threshold. And it's great for small companies because, like I said, you can appoint a single director. It can be just you. It can be just you as the shareholder. Now, you also don't need to hold annual general meetings, which is something that's mandated for all companies. Because when you think about it, as a small company, it's just you. Who will you be meeting with, right? So annual general meetings are not required. Now, directly tied to this issue of annual general meetings is the fact that you would have needed to appoint auditors, you'd have needed to have financial statements that you are submitting at the Corporate Affairs Commission, what we call CAC. But now for small companies, small companies don't need to do that anymore. If you choose to have an auditor and audit your accounts and have audited statements, that's fine, but you're no longer required by this law to do so. And finally, you don't need to appoint a company secretary. Now, having said all of this, this is great for small companies, but I always say not everything that's available is good, and not everything that's good is available. Now, this is what I mean. If as an entrepreneur, you're talking to a bank to receive some sort of facility to grow your business, and the bank insists that you must have at least 2 shareholders, it would be completely impractical to be arguing with the bank and saying, no, but CAMA says I am allowed to have a single shareholder. If that is what the bank requires, then as a practical matter, and just in the interest of self-preservation, I would recommend that you go ahead and get a second shareholder. Same thing with equity investors who are looking to invest in your business, invest in your idea. If they insist that, look, I love the idea, but just to mitigate things like key man risk, where if something happens to you, who will move this business forward? Let there be someone else. Then if they want you to mitigate that risk by having a second shareholder or a second director, then you will need to do that. Otherwise, you may lose the benefit of that investment. So that's why I say, even though these incentives are great, ultimately you will need to look at your particular circumstances before you decide on whether or not you actually want to take advantage of these benefits. The third is the electronic innovations that are in the Act. Look, let's face it, there used to be a lot of paperwork, print this, sign that, scan it, submit the originals. A lot of those things could in practice be problematic because you want to focus on your business, you just want to get on with it. Now, the electronic innovations that are in the Act are great because it means you can do a lot of things electronically online. So for example, all companies are required to have a register of shareholders, register of directors, and pre-CAMA 2020, you needed to keep those books in physical form, like an actual book. I'll show you, like an actual book like this. Now, you no longer need to do that. All your registers can be kept electronically in Excel spreadsheets or just soft copies of Word documents. So that's fine. It also means for those of us who are green, we're not printing paper and having books lying around the office that are unnecessary. If you want to sell shares in your company, you can now do that using electronic share transfer forms. So what it just means is that you will affix your signature digitally. You don't need to print it, sign it, scan it, and sign it, give it to the other party to sign, courier documents all over the world. You don't need to do that anymore. So it's great. Now, for those entrepreneurs in our midst who are not small companies, but they are private companies anyway, you still need to hold annual general meetings. But what it means is that but what will happen now going forward is that you can hold your annual general meeting electronically, which is great because in COVID, nobody really wants to be gathering in a room with a bunch of other people. And you will just need to ensure that in your articles of association, that's the document that you would have had when you were incorporated for those of us who are companies. You'll just need to ensure that in your articles, you sort of prescribed how you hold those meetings electronically. And then returns that you file at the CAC, maybe you appoint a new director, you have a new shareholder that's coming, and you want to file it at CAC, we can now do all of those electronically. Now, CAC has not yet come up with the process by which these electronic innovations will actually happen. That's fine. We expect that there will be a transition period. But once they do, we will, of course, update the market and people will begin to implement their transactions going forward using those electronic means. Okay, I talked about having articles of association. In old CAMA, everybody was required to follow the model articles that were in the CAMA. Now, you don't necessarily need to do that. While you can still have model articles, you can also draft it as you like. You can exclude any provisions that will be in those model articles as you like, which is great. For those who are companies who had something called an authorized share capital, we no longer have that concept under Nigerian law. Now, what we're required to have is minimum issued share capital. And for entrepreneurs, this is great because it means that the share capital that you have is truly reflective of your capital as a company. So, and another thing that this does is that that front loading of costs where you are creating a company with 10 million naira share capital, you're only issuing ₦1 million, but you've created these 10 million shares, you pay CAC filing fees on 10 million shares, you pay stamp duty on 10 million shares. You no longer need to incur those costs. Now, if you're setting up your company, you can set it up with the 1 million shares that you are issuing to yourself or to yourself and your partner, and then you pay your filing fees on that. And that's it, and that's great. When you want to issue additional shares to someone, you simply issue those additional shares, and that has the effect of increasing your share capital. For those of us here that are private companies, there are a couple of things that we will need to know in relation to how we sell shares to a new shareholder or even how we sell our assets. For private companies in the past, you couldn't sell your shares without getting some sort of approval from your board. And your board it could be your family, it could be your investors, it could be anyone. But that board of directors was required to sign a resolution approving the transfer. And that's because in CAMA, all private companies were required to restrict the transfer of shares in their companies. Now, there's some language in CAMA, in the new CAMA, that suggests that in addition to that restriction, the company may also restrict certain other things. And those other things have to do with things like if you want to sell your assets, you will need, or if you want to sell more than 50% of your assets, you will need all the shareholders to agree. But you see, that's problematic because getting all the shareholders to agree may not be as feasible as we think. And then the second is if you are getting a new investor into your company, or rather if you are selling the bulk of your shares, which amount to more than 50% of the company, and you have other shareholders, that investor who's acquiring your shares will also need to offer to acquire the shares of the remaining shareholders. So any investor that you're speaking to will need to take this into consideration as they think about funding the transaction. Now, it's not compulsory. The other remaining shareholders they're not forced to sell their shares if they don't want to, but it's just something that we need to think about. And then the third is that when you want to exit, you will need to offer your shares to your fellow shareholders before you can offer it to a third party who is not a shareholder. Now, these three restrictions as they are, it's not, the drafting of the law is not clear. It's not clear whether these three restrictions apply mandatorily and then you can exclude them in your articles. It's not clear, or whether they don't apply, but if you want them to apply, you include them in your articles. The language is just not clear, but we hope that when the CAC issues regulations, it will clarify this. Now, most lawyers in Nigeria, the plan is to advise clients to just exclude it in your articles so that when you want to exit or when you want to carry out any transactions, issue shares to new investors, you are not bogged down by all these restrictions. So it's just something to pay attention to as you either think of admitting new investors, selling assets to raise, or selling assets to raise capital. Another thing that may now be relevant to those in the room who are not companies is the fact that CAMA has now introduced two new structures, which are limited partnerships and limited liability partnerships. Now, pre-CAMA 2020, these structures existed, but they only existed in Lagos State. So you could only register these two types of entities in Lagos State. Now, while the legislative competence of Lagos State House of Assembly to create laws, there's no question, they can create laws. There was always this debate about this limited liability partnership. Is this something that a state can create? Because limited liability is supposed to be covered by a federal statute. I'm not going to get into those technicalities. The fact of the matter is that that debate has essentially been put to bed. And if you want to set up either a limited partnership or a limited liability partnership, you can do so under this act. And these two vehicles are great for entrepreneurs as well because they're very flexible. Setting them up is fairly straightforward. You fill a document. Now, CSC has not yet set out the guidelines, but in the act at least there is some information there. And you fill an incorporation statement with the information that you want, the name of the partnership, who the partners will be, your registered address, just general information on the entity, and you submit it at the CAC, and it's supposed to be registered fairly quickly. And even in terms of how you administer these sorts of entities, again, everything will be set out in a partnership agreement. And then they don't have this concept of share capital. It doesn't apply to partnerships. The partners just agree that we are going to contribute either cash, or we're going to contribute services, or we're going to contribute land. You can contribute whatever it is you want. And what it just means is that you will agree in the partnership agreement that these are the forms of consideration forms of payments that we will receive from investors, and that's it. It's also easy to dissolve. So if the partnership is no longer working, there's no problem. You just pass your resolution, and you'd have drafted it into your agreement that if you want to terminate, maybe 50% of the partners can agree or 75% can agree. It is whatever you choose, however you choose that the partnership will be dissolved, and whatever you have written into the agreement, that is how it will be done. As opposed to companies where if a company wants to be liquidated, you need at least 75% of the shareholders to agree. Again, if there is fights, it becomes harder to get people to agree to dissolve this business. So, so it's much easier, it's more flexible. So these vehicles, for entrepreneurs who don't necessarily want to be set up as companies, but do want some sort of corporate structure, slightly different from a business name, you can consider these two vehicles to use going forward. If there's anyone in the room who has ever considered taking debts and has freaked out at the sheer cost of registering security, there is good news for you. That cost has reduced drastically. Now, if you've ever approached a bank and they've said, okay, we will give you this facility, we'll give you this loan, but we will need to take collateral. So maybe we'll take security over this land that you have, or even these assets you want to buy. You will also know that the process of that when they say they will take that security, you will need to enter into some sort of security document. It could be a debenture, it could be a charge document, whatever fancy name the bank is calling it. That security document will have to be registered at CAC. And prior to now, the filing fee that you would have paid to CAC was 1% for private companies and 2% for public companies. This is 1% of the amount secured or 2% of the amount secured. So you can imagine if you are taking a loan of 1 million naira, you've already, let's not talk about the bank charges. You've already taken out another 1% because you want to file at CAC, then you're taking out another 0.375% for stamp duties. The cost of taking security, the cost of even getting facilities, taking a loan, it was becoming ridiculous. So what CAMA has now done is reduce it to 0.35%, and that's the same for all companies. So that's great because it will reduce the cost of debt financing for businesses in Nigeria, especially for small businesses who, this loan, you need every naira accounted for. Apportioning 1% was ridiculous. So this is great. This reduction is great. Yes, common seal, again, for those dealing with, maybe you're dealing with a bank, you're dealing with an investor, you're dealing with a supplier, and you are entering into an agreement that will document the terms of your, that will essentially document the terms that you've agreed. When you are signing that agreement, there would have been a space for director, secretary, or authorized signatories. And then under old CAMA, you would have had to affix your common seal. Now, all of that has been done away with. Companies no longer have to have a common seal. Having said that, I'll go back to the point I made at the beginning, which is the fact that you no longer need to do something does not mean it is not prudent to do it. So if, for example, you're talking to a bank and the bank says, sure, I'll give you this 50 million naira facility, but I need to see your board resolution approving this facility. And you need to, and I want it to be sealed. So, you know, the company seal is the thing that you affix to a piece of paper. That's not the time to be arguing with the bank and saying, I don't have a common seal. CAC said we do. CAMA says we don't need a common seal. No, that's not the time. A common seal is fairly cheap to have. It's very easy to use. Just go ahead, get the company seal, affix the seal to the document and comply with the bank's requirement. Okay, statement of compliance. I'm sure there are some people in the room who haven't even set up any entity at all. You're just doing your business from home and that's fine. But now that all these various structures are available, you're thinking, okay, you know what, let me set up a company, or let me set up a partnership, whatever it is. Under old CAMA, you required a lawyer to sign what was called a statutory declaration of compliance. And it was typically only a lawyer that could do that. Now, that has changed, which is great. It means you can go ahead and incorporate your company yourself and sign your statement of compliance yourself. The statement of compliance simply says everything that's required to be done has been done. All the information provided is true. You can sign it yourself and go ahead and incorporate your company yourself. Now, I know there's been some backlash from the legal community that this seems to be doing away with lawyers, taking away food from lawyers. Maybe, but I think, you know, incorporation is such a small part of things that lawyers do. And ultimately, not everybody can incorporate a company themselves. Not everybody will even know how to fill a statement of compliance. So again, the fact that you can do it yourself doesn't necessarily mean that you should. If you have any questions about the forms, it is always better to get legal advice, just so you know that you're doing things the right way. But if you don't need legal advice, by all means, knock yourself out, do it yourself and save those costs. As an entrepreneur, when nobody is paying you a salary, honestly, and you're running a business yourself and you want that business to be profitable, the foremost thing on our minds is keeping costs low. So I can understand if you want to keep your costs low, this is one of the areas where you can do things yourself. Okay. There are some company rescue processes that have now been introduced, or rather, yes, new company rescue processes. But I won't talk, because of time, I won't talk about these in detail. But the one thing that we should all know is that winding up is no longer the only option that's available for companies that are in distress. The company can be put into administration, for example, where an administrator is appointed to sort of manage the affairs of the company, to figure out a way to rescue the business. But maybe I shouldn't talk about that here, because I'm talking to growing businesses. I'm not talking to businesses that are about to fail. So let me leave that. But the other thing directly tied to this point about company rescue procedures is the fact that the insolvency test for companies has changed. So prior to CAMA 2020, we used to see incidents where you have a creditor, you're owing the creditor 100,000 naira. And then the creditor comes and says, okay, where's my 100,000 naira? You don't have the 100,000 naira to pay. Then all of a sudden, the creditor goes and applies to court for your company to be wound up. Why? Because under CAMA, if you can't pay debts of 2,000 naira and above, suddenly you're an insolvent company and you can be wound up by a creditor. It was ridiculous. So you now had a flurry of these spurious cases in court, essentially trying to come, is really just to force you to pay the money. So now it's been increased. That test to determine whether or not a company is insolvent has been increased to 200,000 naira to reflect present day realities. Now, we will always have people who will complain. So there are people who have been complaining that, oh, but 200,000 naira, what is that? What is that? Especially now that the dollar is rising. Look, for a small company, 200,000 naira is still a fair enough test. And we need to work with what we have. 200,000 naira may not be where we would have wanted to get to, because it may not be as realistic as we would have hoped, but it's still better than 2,000 naira when people were trying to get people, were applying to court to have people wound up arbitrarily. So again, this is great. It means there's still some room to maneuver. Oh yes, increased transparency. For those of us entrepreneurs who we have investors that want to remain silent, so maybe you're talking to maybe a rich uncle that happens to be a former governor, and they've given you money, but they've said, oh, you don't put my name on your books. There are now these disclosures that apply to private companies and public companies, where if there is anyone who has significant control, who holds more than 5% of your shares, it will need to be recorded in a register. And that information will also need to be provided to the CAC. So this is just something that you will just need to bear in mind. Now, there are still a lot of avenues for getting around this. People can still appoint personal representatives. People can still appoint trustees. You can have a blind trust. There are so many structures that you can use. But just have it at the back of your mind that if somebody holds more than 5% of your company and they're not named, they were not formally named on the books in any way, you may need to start thinking about how you're going to deal with that going forward. I don't know if there are any NGOs or not-for-profit organizations in the room, but just in case there are, and there are any who have attempted to register a company limited by guarantee before today, if you have, you will understand the difficulty with doing so. So you have a charity, you want to do good work. Maybe you're setting it up as a company limited by guarantee that will provide maybe free healthcare in your village. And then you go to the Attorney General's office, which was one of the requirements. You needed his consent before you could incorporate this company limited by guarantee. And then you were there for 6 months, a year, and you were frustrated. A new alternative method has been included in CAMA, which will help you. Now, what CAMA says, it has essentially forced and abridged that timeline to make it shorter. So what CAMA now says is if you apply to the Attorney General's office and you don't hear from him in 30 days, like there's total silence, which has happened in the past, and there's total silence, then You can advertise your application to be incorporated as a company limited by guarantee, a non-profit. You can advertise it in the newspapers, 3 newspapers. And then if there are no objections that are received, the CAC will then consider your application and then also advertise as well in the newspapers. And if the CAC does not receive any objections in 28 days, they can go ahead and register you, and they don't need to wait for the RG's consent. So for those who have a lot of ideas regarding charitable activities that they want to be involved in, and you want to set up a company limited by guarantee for this purpose, then this is great news for you. Just to add, use the minimum amount that had to be contributed by, or let me put it this way, if the company limited by guarantee is going to be dissolved in the future, the minimum amount that needed to be contributed to the assets, it used to be 10,000 naira, but that's now increased to 100,000 naira. But again, to reflect present day realities, but when you think about it, this is not going to be such a big issue because, first of all, how many companies limited by guarantee wind up and get dissolved? And 2, if you've been doing all this charitable work in your village, you will still have you should still have 100,000 naira to contribute to the assets, only if you need it to settle any outstanding debts and liabilities. Financial assistance. Okay, we used to advise on certain transactions whereby, so for example, you're trying to receive an investment from an investor, and that investor wants you to provide certain guarantees that, okay, you've run your business in a particular way, the books are fine, everything is true, and if it's not true, you will indemnify me, essentially, you will make me whole, you pay me some money. There was always the question regarding those sorts of arrangements around whether they were lawful. And that's because those sorts of arrangements were deemed to be unlawful financial assistance. Now, the penalty was 500 naira, but it was considered to be an offense. So we always had investors who were a little bit careful, who were a little bit skittish around those arrangements. They were always uncomfortable. They didn't know how to deal with it, structure around it. And it used to affect a lot of transactions. You have a company, you're an entrepreneur, you're trying to raise money, and you have an investor that's a little bit skittish. You yourself are a little bit skittish around giving this sort of guarantee. Now, CAMA 2020 has expanded. There were exceptions that were available, but those exceptions were very limited, and they never applied to any regular transaction. It was things like if you're trying to fund an employee share scheme, so shares you want to issue to your employees under a scheme, if you want to fund that, that's not what we're talking about here. So now CAMA 2020 has expanded the exceptions that are available for you. The first being, if the court sanctions it, great. So you can get a court order to sanction it and you're fine. The second, which we think that a lot of people will apply going forward, is the fact that if the assistance that you're giving, so if that guarantee that you're giving to an investor who's going to take your shares, or that indemnity, or whatever it is, that warranty, for those of us who have dealt with representations and warranties that investors want us to give in relation to the business, if you are doing all of that as part of a larger transaction, being the investment is going to come in, is being done in the best interest of the company. So you really need those funds, and you're doing it in good faith. So it's not a roundabout way to assist someone to acquire your shares. No, it's really being done in good faith in the best interest of the company. Then that arrangement will not be unlawful. So this is great because it means that now all of that discomfort, all of that fear around, if I give this investor this guarantee, if I give this investor this indemnity before they invest in my shares, is it lawful? That fear has essentially been removed. The other exemptions, which are great and which apply to private companies, is the fact that you can essentially do what's called, you can whitewash it. So you can clean this financial assistance by passing a special resolution. And if you fund it, so if you have profits available, you fund it from your profits, and then you, of course, the net assets should not be reduced, but it's if they are reduced that you fund it from profit. And then the directors make a statutory declaration in some form that the CAC will prescribe. We've not seen the form yet, but if the directors feel that statutory declaration, then it's not unlawful. Whatever you do is not unlawful. This applies particularly to private companies. So that's great. It essentially means that if you do these things that I've said, you pass your special resolution, you fund it from profits, you can go ahead and structure a transaction however you like, financial assistance be darned, quote and unquote. So it's a really great, it's a really welcome development, because it means you will be able to attract the investment that you need, execute your deals, and move forward. So that's great. Oh dear, I'm running out of time. Another thing that used to be prohibited was you buying back your shares. So you know how you have another shareholder in your company who's becoming problematic, or even when the shareholder invested, they said, look, I will only invest for 5 years, and after that, I need the company to buy back my shares. Now, prior to CAMA 2020, all of that was prohibited. There were limited circumstances, but again, they hardly ever applied in real life. Now there are more exceptions that are available that you can rely on. So if the company approves it by a special resolution is a resolution that's approved by 75% of the shareholders by value. So it's not that there are 4 people sitting in a room, 3 people who hold 10% each approve. No, it is the people who hold 75% of the shares. If they approve it, then the resolution is passed. So if those people approve the shares, if you are buying the shares on an open market, if it's permitted in your articles, then you can buy back the shares. And I would be happy to provide advice on this much later if you need to, but it's just a good way for you to know that, look, even if you as a shareholder, you can't afford to fund the acquisition, the company, if they have the profits available, can fund it. Okay, I'll just power through very quickly. Oh yes, there's something new that has been introduced into CAMA that I think we should know. It's the fact that if you, as a director, the company removes you from the board, and there's a process by which a company can remove you from a board. They pass this, they call a meeting, 50% of the shareholders remove you in that meeting. They give you the opportunity to make your representations, but if they don't agree, you are removed. If you are removed as a director, you will not be permitted to act as a director of any other company. We may not like this, we may not agree with this, but this is what it is. One way to deal with this as a director is, instead of being removed, please just resign and go. At least it is better for you to resign. Sack yourself before they sack you. It's better for you to resign and go than for you to be removed. Now, I know that for entrepreneurs, this one in particular will be a very, very touchy issue, because you can imagine if you founded a company, you brought in investors, things broke down, all of a sudden people who are in the majority remove you and you now can't be a shareholder, you now can't be a director in any other company. I see how the market sees how it can be problematic. But again, it's something that you can deal with by negotiating with your board, negotiating with your shareholders, negotiating with your partners on how to resolve any issues, so that instead of being removed, you can just resign peacefully. For those who were worried about penalties in the past, where everything and its dog was a penalty, or rather was an offense, a criminal offense, those sorts of things. All those criminal offenses have now become administrative offenses. Now, the fines that used to be in the Act, 5 naira, 20 naira, they were ridiculous. So what has happened now is, it is the CAC that will prescribe fines in its regulations. So, but please, no need to panic. What it just means is that whatever it prescribes, the Minister of Trade, which is the supervisor essentially of the CAC, will first have to approve those fines before they go into the regulations. And it is our hope that the fines will be reasonable. But ultimately, instead of having to amend the acts all the time to reflect what the new fines should be, It's just that now CAC will prescribe it and things will be more administrative rather than any small thing and you have a criminal conviction on your record. So it's just something I thought I should also mention. So we know, but I know we are all law-abiding citizens here, so it shouldn't be an issue. So that's it from me. I'll stop here because I know I have already gone past my time. So thank you. I'll stop here for any questions.
Wow, Christine, thank you so much for the fantastic presentation. I learned so much from you today. Like your passion, as you said in the beginning, you're very passionate about the subject of law and entrepreneurship. So we do have some questions. So anyone with any question, please go ahead in the Q&A. Christine, there's some question. I think you can see some of the questions, right? And you can answer them live. So the first question is registering. I mean, you can read the question and answer them.
Okay, I'm just reading the questions now.
Mm-hmm.
Yes, I can share the slides as well afterwards. Registering a business name enough to kickstart a business? Okay, no. So I have a question here from Innocent Oyebode who says, is registering a business name enough to kickstart a business as a company? No, and that's because a business name is a different kind of vehicle. Business names are useful for like sole proprietorships or people who don't want to be as heavily regulated as companies. Now, what it also means is that as a business name, you don't enjoy limited liability. So if there's any debts, just know that as the proprietor of that business name, you will have to pay for it, you'll have to settle it, you'll have to deal with it. We've also found that in talking to banks, banks sort of prefer to deal with, they prefer to provide facilities and credit to actual companies rather than business names. So no, it's a completely different kind of vehicle. If you want to set up a company, you set up a company. That's not to say you can't do your business as a business name. Like I said, the women in Surah that are selling provisions, most of them are business names. I have a lot of friends who they do furniture, the makeup industry, whatever it is. Some of them are set up as business names. I have a side hustle. I bake cakes at Christmas, every Christmas, and I do it commercially. That entity is a business name. So again, it really depends on your preference. I am still thinking about whether I want to upgrade to a partnership or not. I haven't decided. It really depends on my business needs. And right now, I don't need to be anything other than a business name. So if you don't need to be, but to kickstart your business, yes, you can register a business name. Innocent also asked a question, if you're removed as a director of a company and thus not being able to be a director in any other company going forward, does it imply you cannot start a company of your own again? Yes, you can start a company of your own again, but it implies that you cannot be a director of that company. You can only be a shareholder. So you can be the majority shareholder with the right to appoint whoever you choose as directors. But what it means is that you yourself can't be a director. So we already know that this is one of those things that the market is going to clamor for amendments going forward. Or they may not. They may decide, you know what, maybe it makes sense so that unruly directors won't hold us to ransom, because we do have some of those unruly directors. But yes, that's what it means. You won't be able to be a director of a company going forward. I think those are the only questions that I have. I don't know. Thank you, Elaine Shobanjo, for your comments. Thank you. Adekunle, yes, we will send the slides. We'll share the slides. Yeah, okay, so, but that's it from me, 54 minutes. I know that Christine had said we have to stick to an hour. So that's it from me. For companies registered many years ago, how do we amend the way we were previously set up to reflect the new CAMA? Okay, thank you, Elaine. Very good question. The one question that we have received consistently since the act was passed is the question around, if you were two shareholders before and you're a small company, can you, or you're a private company, can you become a single shareholder? And the answer to that is yes. If you are able to figure out a way to buy out your second shareholder, then you can become a single member company and you will not be in breach of the act if you do so. So again, that's great. If you're a single, if you had two directors before, and the other director was only there because you wanted to comply with old CAMA, then you don't, if the other director is willing to resign, of course, then you don't need to have the second director. You can ask him to resign and you become a single director. And it's great, you're not in breach. So anything that you need, any steps you need to take to restructure your company the way that you like, it's now going to be fairly straightforward. And I'll be more than happy to talk you through the process if you need any help with doing that. Okay. Seeing more questions coming in. You mentioned 75% as a threshold to liquidate a company. What if you need to withdraw shares from a non-performing partner? Okay, if you need to withdraw the shares, and this is why I always advise people to have some sort of vesting mechanism in place where you can agree that your partner will receive 50%, but he doesn't get the 50% on day one. So maybe he'll get the 10% if he does X, he'll get another 10% if he does Y. The reason that I say this is because you don't want to find yourself in a situation where you've essentially given somebody 30% of your shares and they didn't perform. There's nothing more crushing than that. Now, if you want to get those shares back, you just need to have a conversation with that partner. If they didn't pay anything for the shares, you shouldn't have to pay them any money. That is what logic suggests. Unfortunately, in reality, you find that some people hold you to ransom and then they start coming up with, oh, but I did this and I did that. And you're like, no, you didn't. But that, you see, at that point, it's a debate that could have been avoided if you agreed how the shares would vest over time or if they meet certain milestones. So you will just need to have a conversation with them around surrendering the shares to the company or around even the company buying back the shares. You can have a conversation. You will still need 75% to approve it because it's a share buyback, but at least you don't need to talk about winding up the company. So I don't know why you're referring to, okay, so you were asking about the threshold. Yes, it will be 75% that you will need to approve that acquisition from that non-performing shareholder. I hope that answers your question. Tukdat Dabgat. I hope I got the pronunciation right. Okay. Okay, thanks.
Thank you so much, Christine, for your time. And thank you, everyone, for joining us. Without further ado, Christine will be sharing the presentation with us. And we are so, so glad to having you here with us today. And if there's anything, please let us know and we will transfer all conversation to her. Christine, thank you so much on behalf of AfricaHacks for allowing us 1 hour of your time. And without further ado, we'll adjourn the meeting. And thank you so much.
Thank you. Thank you very much for having me. And I'm available if you have any questions, just let me know, send me a message, you can call me, send me a direct message. I'd be happy to answer them. Thank you for having me, Christine. It was great chatting with you all. Thank you.
Thank you so much. Have an amazing day. Goodbye now.
Thank you. Bye, everyone.
Bye. Want to say something? Hello?